in the merger that took place.
Which merger? You've listed many.
Involving American Express GBT. I understand that Brian Ballard, longtime backer and head of the law firm where you worked, was instrumental in lobbying the Justice Department to drop that lawsuit. It was dismissed, so it's not subject to a court review. What conversations did you have with Mr. Ballard?
Senator Blumenthal, I cannot believe that you would accuse me of impropriety when you lied about your military service.
I am
you
not
lied.
asking
You admitted you
I am
lied
not
to be
accusing
elected a
you of
U.S. senator.
impropriety.
You
I'm asking
lied.
you
How
about
dare you? I'm a career prosecutor.
with Mr.
Don't you
Ballard,
ever challenge my integrity. I have abided by every ethics standard. Do not question my ability to be fair and impartial as Attorney General, and anything with my former firm, Ballard Partners.
Thank you.
Hi, buddies. Adam is here. There is a moment in congressional hearings that every cabinet official dreads but few actually experience. The moment when a carefully prepared testimony, rehearsed for days with advisors, vetted by department lawyers, and calibrated to survive any political attack, suddenly collapses in real time because the person testifying made one specific mistake.
This is so ridiculous, and that they are trying to deflect from all the great things Donald Trump has done. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. He's the one that asked that those files.
I'm going to claim my time. I got your answer. You said there's no evidence.
Trump asked
Mr. Chairman, please stop the clock.
Stop the clock. The legislation. This is
time
belongs to the gentleman from California.
Okay. I'm going to put up another document from a witness who called the FBI's National Threat Operations Center, because I believe you just lied under oath. There is ample evidence in the Epstein file.
Don't you ever accuse me of a crime.
I believe you just lied under oath, and this is all on videotape. You said there's no evidence of a crime. I'm showing you.
They made a sweeping factual claim under oath that the documentary evidence in the room could immediately and publicly destroy. That moment is the accountability event that no amount of spin can undo. It is the moment when the cameras capture something permanent. The witness's face as they realize the documents in front of them contradict what they just told Congress and the country.
Let me show you what actually happened. First, in violation of the law, your department has shown a pattern of redacting the names of powerful predators. Here behind me is one example of an email from Epstein to a man whose name was redacted. The email reads, quote, "Where are you? Are you okay? I loved the torture video." Only after members of Congress demanded that we see the unredacted files did the world learn the name of this individual, Sultan Ahmed bin Sulayem, the chairman and CEO of a company that had financial ties to President Trump's business and personal ties to Trump's advisor, Steve Bannon. Second, the survivors were not similarly protected, also in violation of the law. Here is another email titled Epstein Victim List.
Pam Bondi lived that moment on February 11, 2026, at the House Judiciary hearing on the Epstein files. And the specific claim that triggered the collapse was one of the most politically explosive statements any attorney general could make about the most toxic accountability story simultaneously active in American politics. Representative Ted Lieu asked Bondi a direct question. Was there any evidence Donald Trump committed a crime related to Epstein? Bondi answered without hesitation. There is no evidence Donald Trump committed a crime. Let that sink in. The Attorney General of the United States, under oath, told Congress and the American people that no evidence exists connecting Donald Trump to criminal conduct involving Jeffrey Epstein. That statement lasted approximately 3 seconds before the documentary reality of her own Justice Department's files reached up and strangled it in front of the cameras. Because here is what Bondi apparently forgot in that moment. The DOJ's own Epstein files, managed and released under her own authority, contain sworn statements from a woman who says under penalty of perjury that Donald Trump raped her when she was a minor. They contain FBI interview summaries documenting explicit sexual assault allegations against Trump. They contain the specific categories of documentary material that the legal system defines as evidence regardless of whether that evidence has produced charges or convictions. And Representative Lieu had those documents ready. The moment the words left Bondi's mouth, Lieu pounced. He accused her of lying under oath. He pointed directly to the sworn survivor statement and the FBI summaries sitting in the public record, and Bondi snapped back with a response that will define her tenure as Attorney General forever. "Don't you ever accuse me of a crime." She insisted she had told the truth because, in her professional opinion, unverified allegations and civil claims do not count as evidence of a crime. The DOJ can only charge based on admissible evidence that meets the standard for prosecution, she argued. But Representative Jamie Raskin and other Democrats immediately called that word games. Sworn survivor statements are evidence, they countered. FBI interview memos are evidence. Civil complaints are evidence. Even if DOJ has not indicted Trump, those documents exist and they say what they say. The accusation against Bondi escalated from misleading Congress to running a massive Epstein cover-up and siding with perpetrators over victims. And then came the Republican hammer. Thomas Massie, the Republican congressman who wrote much of the Epstein Files Transparency Act, took the floor and demolished Bondi's defense from her own side of the aisle. He accused her of what he called a massive failure to follow the law. He noted that DOJ first released a co-conspirator list that left off billionaire Les Wexner's name entirely. They only added Wexner after Massie caught them red-handed and forced the correction. A Republican author of the Transparency Law telling a Republican attorney general that her department got caught deliberately omitting required information. That is the specific moment when any pretense of partisan opposition to the accountability narrative collapsed. In the immediate wake of the hearing, Representatives Ted Lieu and Dan Goldman formally requested a special counsel investigation into Bondi's handling of the Epstein files and her sworn testimony about them. The House Oversight Committee voted on a bipartisan 24-19 margin to subpoena her for a closed-door deposition to determine whether she misled Congress about Trump and Epstein. And the Justice Department itself announced an internal review into whether it had improperly withheld Epstein records, specifically including interview notes from the woman who says Trump and Epstein sexually assaulted her as a minor in the 1980s. An attorney general walked into a congressional hearing and told the country there was no evidence Donald Trump committed a crime. She watched in real time as Democrats forced into the hearing record the specific sworn survivor statements and FBI memos from her own department's files that most directly contradict that claim. She defended the claim through a definitional argument about what counts as evidence that Democrats immediately and publicly characterized as word games. And now she faces a special counsel demand, a congressional subpoena for sworn testimony under a perjury lock, and an internal DOJ review into whether the documents most relevant to her claim were improperly withheld from public view. This is the most explosive single hearing moment in the entire Epstein files accountability story, not because a judge has ruled she committed perjury, but because the factual record she tried to present was publicly dismantled in real time by the specific documentary evidence her own department produced under the transparency law she has been accused of selectively executing. Let's break this down systematically, because the Bondi hearing has 4 distinct dimensions that each need to be understood separately before the complete accountability picture comes into focus. The first dimension is the no evidence claim itself and why its sweeping nature made it uniquely vulnerable to immediate documentary contradiction. The second dimension is the don't you ever accuse me defensive response and why that emotional snapback became the most damaging single moment of the hearing. The third dimension is the Massie red-handed finding and what it means when the Republican author of the Transparency Law catches the administration omitting required information. The fourth dimension is the post-hearing accountability wave and what the special counsel demand the oversight subpoena, and the internal DOJ review together establish about the institutional response to Bondi's testimony. Start with the no evidence claim because understanding why it exploded requires understanding what Bondi actually said versus what she could have said. The question was whether any evidence exists that Trump committed a crime related to Epstein. Bondi answered with a flat, sweeping denial. No evidence. That formulation is the most legally exposed statement she could have made because no evidence means exactly what it says. It means the complete absence of any documentary material, any witness statement, any investigative record that could be classified as evidence under any definition. But her own department's files contain sworn statements from a woman who says Trump raped her. They contain FBI summaries documenting those allegations. Those are evidence by any reasonable definition of the term. A more carefully calibrated answer would have been no evidence that meets the standard for federal prosecution, or no admissible evidence sufficient to support charges, or no evidence that has resulted in an indictment. Any of those formulations would have created definitional room to maneuver, but Bondi chose the absolute formulation. No evidence. And absolute formulations invite absolute contradictions. Lieu walked into that hearing with the specific documents designed to produce exactly that contradiction. The moment Bondi made her claim, he had her. The sworn survivor statement is evidence. The FBI summaries are evidence. The contradiction was immediate, public, and permanent. The "don't you ever accuse me of a crime" response is what transformed a factual dispute into a political disaster. Imagine for a moment how a witness who genuinely believed their statement was accurate would respond to an accusation of lying under oath. They would remain calm. They would cite the legal framework supporting their position. They would explain the distinction between unverified allegations and prosecutable evidence. They would invite the committee to examine the specific legal standards governing what constitutes evidence for charging decisions. That is what a confident attorney general confident in her testimony would do. Instead, Bondi snapped, "Don't you ever accuse me of a crime. That is not the response of someone calmly defending a legally defensible position. That is the response of someone whose emotional defense mechanisms activated the moment they realized the documentary trap had closed around them." The snapback is the moment that will be replayed in every future coverage of this hearing. Not because it proves perjury as a legal matter, but because it communicates something that legal arguments cannot erase. It communicates that Bondi knew in that moment that the documents in front of her exposed a vulnerability in her sworn statement that no amount of definitional word games could fully repair. The Massie intervention is what gives this story its bipartisan accountability dimension and makes it impossible for the administration to dismiss as Democratic political theater. Thomas Massie is not Jamie Raskin. Massie is the Republican author of the Epstein Files Transparency Act. He is the congressional actor whose voice carries the most authority on what the law requires and whether the administration has complied with it. When Massie stood up and told Bondi that her department committed a massive failure to follow the law, he was not making a partisan argument. He was making a statutory assessment based on his own role in drafting the very legislation at issue. And when Massie revealed that DOJ first released a co-conspirator list omitting Les Wexner's name and only added it after he caught them red-handed and forced the correction, he established something more damaging than any Democratic accusation could. He established a pattern. The Wexner omission was not an accident. It was a deliberate omission that required external intervention to correct. And that pattern of selective disclosure is the specific context that makes Bondi's no evidence claim about Trump most vulnerable. If the department was selectively omitting names from required disclosure lists, what else was it selectively framing in its public representations about the contents of those files? Massie's red-handed characterization is the specific language that most directly communicates intentional conduct rather than administrative error. And that intentional conduct framing is what the special counsel demand and the internal review are now built to investigate. The post-hearing accountability wave is where this story moves from a single hearing moment to a sustained institutional crisis. The special counsel demand from Lieu and Goldman is significant because it signals that the members most directly involved in the hearing believe the standard oversight mechanisms are insufficient to address what happened. They are asking for an independent investigation precisely because they do not trust the existing DOJ chain of command to investigate its own Attorney General's testimony about its own files. The Oversight Committee subpoena for a closed-door videotaped deposition is even more significant because of the perjury lock mechanism it creates. In a closed-door deposition, every answer Bondi gives is a sworn statement that can be compared against every internal DOJ document, every email, every memo, every note about what she knew and when she knew it. The perjury lock is designed to catch any inconsistency between her testimony and the documentary record. And the internal DOJ review into whether Epstein records were improperly withheld is the single most institutionally significant development because it represents the department's own acknowledgement that the post-hearing pressure is serious enough to require self-examination. A DOJ that was publicly defending its Epstein file management as fully compliant with transparency laws in the hearing itself is now reviewing whether that management was improper. That shift from defense to internal review is the specific institutional response that most directly validates the concerns raised by Bondi's accusers. Let's focus specifically on the interview notes that are now the subject of the internal review. The woman who says Trump and Epstein sexually assaulted her as a minor in the 1980s gave interviews to the FBI. Those interviews produced notes. Those notes are documentary evidence of her allegations regardless of whether those allegations have been independently verified or resulted in charges. The question the internal review is now examining is whether those notes were improperly withheld from the public release that the transparency law required. And the connection between that withholding question and Bondi's no evidence claim is direct and undeniable. If notes containing explicit sexual assault allegations against Trump were withheld from public view, then Bondi's claim that no evidence exists of Trump committing a crime was made in a context where the department had intentionally kept specific evidence out of public view. That is not a coincidence. That is a pattern. And the internal review's focus on those specific notes is the clearest possible signal that the department understands exactly how damaging that connection could become if the review confirms the allegations of improper withholding. Here is what makes this entire sequence so devastating for Bondi and the administration. The no evidence claim was supposed to be a protective statement. It was supposed to shut down questions about Trump's involvement with Epstein by asserting the complete absence of any evidentiary basis for criminal allegations. Instead, it became the precise statement that most directly invited the documentary contradiction that now threatens to consume her tenure as Attorney General. The protective statement became the trap. And the trap was sprung not by some external investigator discovering new information, but by the documents her own department had already collected and managed and partially released. The evidence that destroyed her testimony was sitting in her own files the entire time. She just assumed she could define it away. And the definitional argument about what counts as evidence is now the central focus of the special counsel demand, the oversight subpoena, and the internal review. Because if sworn survivor statements and FBI interview summaries are not evidence, then what exactly is the standard? And who decides? And on what authority does the Attorney General decide that documents in her own investigative files do not count as evidence when she is testifying under oath about whether evidence exists? The Republicans who voted with Democrats to subpoena Bondi for a closed-door deposition understood something that the administration's defense strategy has not yet acknowledged. The no evidence claim cannot survive the documentary record. The only question is how many different investigations and reviews will be required to fully document the gap between what Bondi said and what her own files contained. The 24-19 bipartisan vote for the subpoena is the specific institutional signal that the hearing's accountability moment transcended partisan lines. 19 Republicans voted against the subpoena, but 24 voted for it. That margin means enough Republicans crossed over to join with Democrats to create a majority. That does not happen unless the members making that decision believe the factual record is strong enough to justify investigating their own party's attorney general. Let's land on the 4 points that matter most. Point 1. Bondi's no evidence claim was the specific, sweeping affirmative statement most vulnerable to immediate documentary contradiction, and her own department's files containing sworn survivor statements and FBI summaries provided exactly that contradiction in real time. The flatness of the denial is what made the collapse inevitable. Point 2. The "don't you ever accuse me" snapback was the most politically damaging moment because it communicated defensiveness rather than confident institutional authority, and that emotional response will be replayed in every future coverage, as the moment Bondi revealed she knew the documents had exposed her. Point 3. Massie's red-handed finding about the Wexner omission established a pattern of selective disclosure from the same department managing the Epstein files, and his same party accountability voice defeats any attempt to dismiss the hearing as partisan theater. Point 4. The special counsel demand, the oversight subpoena with its perjury lock mechanism, and the internal DOJ review into improperly withheld interview notes together create a multi-tracked accountability architecture that will examine every aspect of Bondi's testimony and the department's file management from every possible angle. The Attorney General walked into that hearing room on February 11th expecting to deliver a managed political defense of the administration's Epstein file handling. She walked out having made the single most consequential sworn statement of her entire tenure, a statement that was publicly dismantled before she even left the witness table. And now every subsequent development in this story, the special counsel decision, the closed-door deposition testimony, the internal review findings, will be measured against the gap between what Bondi said and what her own files contained. That gap is not closing. It is widening with every new document review, every new deposition preparation, every new institutional response to the accountability pressure the hearing created. And the widening gap is the specific reason this story is not going away. It is just beginning.